So when you look at the fundamental architecture of a legal system, there's this inherent friction built right into the design.
Oh, absolutely. It's unavoidable.
Right. You have the immense, just massive coercive machinery of the state on one side, and then on the other, you have the fragile, heavily guarded liberties of the individual.
Yeah, and usually we expect procedural law to act as this highly calibrated pressure valve between the two.
Exactly. But what happens when that valve fails? Because you don't just get a technical malfunction, you get a full-blown crisis of statecraft.
You really do. I mean, you get a situation where the foundational premise of civil society is just suddenly up for grabs.
It's terrifying when you think about it.
It is. We entrust law enforcement with the authority to suspend our liberties, right?
Right.
But that trust is entirely predicated on transparency and justification.
And if you take away that justification,
Then the authority itself mutates into something completely unrecognizable, something really dangerous.
which brings us to the mission for today's deep dive. And we are talking directly to you, our listener, right now.
Yep, pay attention because we are placing you in a very specific high-stakes scenario today.
Okay, let's unpack this. Imagine you are stepping into the shoes of an advanced law student. You are tasked with presenting a formidable, landmark constitutional case to a room full of senior law faculty and, your sharpest peers.
And let me tell you, that is a tough room.
Oh, the toughest. And you aren't there to just recite a dry case brief. That won't cut it. You are there to deconstruct the actual mechanics of state power.
Right, to command that room, you have to do way more than just list the facts. You need to demonstrate a masterful grasp of how this specific ruling completely redefined the boundaries of executive authority.
You're dissecting a moment when the highest court in the land had to intervene because, well, that procedural pressure valve we mentioned had completely blown.
Well, what's the case?
The case we are arming you to present is the 1994 Supreme Court of India judgment. It's Joginder Kumar versus State of UP and others.
A massive, massive case.
Huge. So, to set the stage for your faculty, you'll naturally need to establish the framework, right? It was decided on April 25th, 1994.
Authored by Chief Justice M.N. Venkateshalaya.
Spot on. And to understand the sheer gravity of this ruling, we have to look really closely at the parties involved.
Yeah, because they represent this terrifying David and Goliath dynamic.
Exactly. So let's talk about the petitioner. Joginder Kumar isn't just an average citizen.
No, he's an enrolled advocate.
Right, a 28-year-old practicing lawyer.
Which is wild. And on the other side, you have the respondents representing the full weight of the state apparatus.
You've got the state of Uttar Pradesh, right?
Yeah, and the Senior Superintendent of Police of Ghaziabad, that's Respondent 4, and the Station House Officer of Police Station Mussoorie, who is Respondent 5.
And as you're presenting this to your faculty, establishing those players immediately signals to your audience that this is an internal systemic failure.
Oh, totally. Because think about it. If a practicing advocate can find himself trapped in the extrajudicial machinery of the state.
What hope does anyone else have?
Exactly. The theoretical protections afforded to an uneducated, marginalized citizen just evaporate entirely.
It's chilling. So let's get right into the factual matrix you'll be presenting, because the inciting incident here is a textbook study in administrative arrogance.
It really is. It begins on January 7, 1994.
Right. So Joginder Kumar is summoned to the SSP's office in Ghaziabad. And the stated reason is innocuous enough, right?
Yeah, just to make quote-unquote inquiries connected to a case.
Inquiries, right. So he arrives at 10 a.m., accompanied by his brothers. He walks in, presents himself to Respondent 4, and
he does not walk out.
he just doesn't.
The initial response from the police when his family questions the delay is, well, it's that standard dismissive bureaucratic deflection.
Nothing to see here, right?
Right. They are told he'll be released by evening after the inquiries conclude. Just sit tight.
But as the hours pass, the facade of a routine inquiry completely shatters.
Yeah, by 12:55 p.m. that very same day, the petitioner's brother recognizes the severe peril Joginder is in.
The brother doesn't mess around.
Not at all. He bypasses local channels entirely and sends the telegram directly to the chief minister of UP.
And the contents of that telegram are crucial for your presentation. You have to mention this because they illustrate the immediate, visceral terror of the situation.
The brother isn't just complaining about, an administrative delay. He is explicitly stating his fear that Joginder will be implicated in a fabricated criminal case.
Or worse.
Much worse. He fears he will be shot dead in a fake encounter.
Wait, really? Within hours of him going to the station, that's where the family's mind goes.
Yes. The escalation from a morning summons to the fear of an extrajudicial execution within 3 hours highlights the intense, deep distrust of the police apparatus at that time.
Wow. And the crazy part is, the subsequent events validate that panic.
They absolutely do. Joginder essentially becomes a ghost in the system.
He just vanishes.
Yeah. The family discovers he's in the custody of the SHO of PS Missouri by that evening.
But they don't let him go?
Nope. The next day, they are told he's being held for further inquiries.
And then it gets worse.
By January 9th, the family is informed he has been moved to an undisclosed destination.
An undisclosed destination. I mean, the sheer audacity of that phrase in a democratic republic.
It's horrifying.
We are talking about an enrolled advocate being bounced between stations, entirely cut off from legal counsel, and crucially, never produced before a magistrate within the constitutionally mandated time frame.
Right, which is 24 hours. And that procedural void is what forces the family to take drastic measures. They bypass the appellate ladder entirely.
Meaning they didn't just go to a local judge?
Yeah, actually. This wasn't a matter of fighting a flawed charge sheet in a trial court and appealing upwards. They couldn't.
Because there were no charges.
Right. So the family filed an original petition directly to the Supreme Court under Article 32 of the Constitution.
Seeking a writ of habeas corpus.
Yes. Literally meaning produce the body.
When you present this to your faculty, you have to emphasize why invoking Article 32 directly was the only viable maneuver here.
It's the constitutional emergency brake.
Perfect way to put it. The state has swallowed a citizen, and the highest court is commanding the executive to physically produce the body and legally justify the detention.
So the Supreme Court issues the notice on January 11th.
And finally, on January 14th, which is a full week after he walked into the station, the SSP appears before the court with Joginder Kumar.
And this is where the state's defense transitions from just concerning to completely absurd.
Oh, this part is nuts.
When the Supreme Court demands to know why this man was detained for 5 days without judicial production, the SSP claims that Joginder Kumar was never actually in detention.
I want to focus on the mechanics of that defense, because it's staggering.
It really is.
The SSP looks at the Supreme Court of India and essentially argues that for 5 days, this 28-year-old lawyer voluntarily ceased all contact with his terrified family.
Just ignored his own legal practice.
Yeah. And it enthusiastically traveled between police stations to cooperate and assist the police in detecting abduction cases.
I mean, it's a semantic game designed to circumvent constitutional safeguards.
Because if they admit he was arrested...
Right. If they concede he was arrested or detained, they immediately have to answer for violating the mandatory production before a magistrate.
So they just changed the label.
Exactly. By labeling it voluntary cooperation, they attempt to place his captivity in this sort of legal blind spot.
But the Supreme Court clearly recognizes the maneuver. I mean, they aren't stupid.
Oh, they saw right through it. While the habeas corpus writ was technically fulfilled because Kumar was physically present and eventually released, the court refuses to just dispose of the matter.
They don't just say, okay, he's here, case closed.
No, they order the district judge of Ghaziabad to conduct a fact-finding inquiry into the detention itself.
And more importantly, they use this glaring systemic failure to address the massive structural legal issue at play.
Here's where it gets really interesting, and this is the pivot point in your presentation.
You transition from the specific abuses suffered by Joginder Kumar to the broader jurisprudential conflict.
Right. The court recognizes that this isn't an isolated incident of local police overreach. It is symptomatic of a fundamental crisis regarding the indiscriminate use of arrest powers.
When outlining the issues encountered, which is point 4 of your format, you have to frame this as the ultimate jurisprudential collision.
It's the expanding horizon of individual human rights crashing directly into society's urgent interest in crime prevention.
It's a structural tension that exists in every legal system, right?
Absolutely. The judgment explicitly references Louis Mayer's, framing this tension as a perennial problem of statecraft.
A perennial problem. I like that.
Yeah. Mayer's observed that striking a functional balance between equipping law enforcement to protect society and protecting the citizen from the oppression of that same law enforcement is an ongoing, shifting challenge.
Like a tightrope walk.
Exactly.
I think we need to deeply interrogate the two opposing legal philosophies the Supreme Court analyzes here, because this is where your faculty will expect rigorous intellectual engagement from you.
What's fascinating here is how the court pulls in Justice Cardozo's perspective from the American case People v. DeFore.
And they contrast it with Judge Learned Hand's philosophy, Let's start with Cardozo.
Okay, so Cardozo's stance is often summarized by his famous warning against letting the criminal go free because the, quote, constable blundered.
Right, so if the police make a mistake, society shouldn't pay the price.
Exactly. Cardozo's position in DeFore represents a heavily utilitarian view of criminal justice.
Society comes first.
Yes. He argues that the paramount obligation of the law is the protection of society from crime. If the police violate a procedural rule, if the constable blunders, Cardozo questions whether the disproportionate remedy is to grant immunity to the criminal.
He acknowledges the danger of the insolence of office, meaning police abuse, right?
He does. But he ultimately concludes that society's need to repress crime must take precedence over an absolute, uncompromising protection of individual procedural rights.
Cardozo is essentially prioritizing substantive justice over procedural justice.
That's a good way to put it.
He's arguing that, say, if a man committed a murder, suppressing the murder weapon just because the police lacked a proper warrant during the search inflicts a far greater wound on society than the illegal search itself.
Right.
But in the context of 1990s India, relying on that philosophy is incredibly dangerous.
Oh, it's a recipe for disaster.
Because if you excuse procedural blunders in a system already plagued by minimal forensic capabilities and a heavy reliance on confessions.
You aren't just excusing a missing warrant.
No, you are implicitly greenlighting the exact kind of arbitrary incommunicado detentions that Joginder Kumar endured.
Precisely.
Yeah.
Which is why the Indian Supreme Court introduces Judge Learned Hand as the necessary counterweight to Cardozo.
And what does Learned Hand say?
Learned Hand recognizes the validity of Cardozo's concern regarding effective prosecution, but he elevates the protection of the individual from state oppression to an equal competing interest.
So he levels the playing field.
Right. Hand argues that perfection is impossible, and therefore criminal proceedings must operate as a compromise.
It's a triage protocol.
Oh, I like that analogy.
Like in an emergency room, you don't admit every single patient who walks through the doors just because they are sick.
Right.
That would collapse the hospital's resources.
Right. You only admit the ones whose condition justifies the intense intervention of an ICU bed.
Exactly. And Learned Hand is suggesting the same for criminal procedure. The state has the power to prosecute, but the application of that power, especially regarding the deprivation of liberty, requires a calibrated, justified compromise, not absolute authority.
And that leads directly to the central thesis of the Joginder Kumar ruling, which is the most critical takeaway for your relevance section. That's point 5 of the presentation.
What's the main takeaway they need to hit?
The Supreme Court established a definitive firewall between the power to arrest and the justification for the arrest.
This is the crux of the presentation right here. Listen closely. Having the statutory authority under the Penal Code to make an arrest does not automatically provide the legal or constitutional justification to execute that arrest.
Just because you can doesn't mean you should. The court states unequivocally that no arrest can be made in a routine manner on a mere allegation of an offense.
Right.
A police officer must be able to justify the arrest apart from simply pointing to their legal power to do so.
And the Supreme Court didn't arrive at this firewall based purely on abstract legal theory.
No, they didn't.
They anchored their ruling in devastating empirical data. And if you want your faculty to understand why this ruling was inevitable, you have to present the statistics cited in the judgment.
The data is shocking. It comes from the third report of the National Police Commission.
And what did they find?
The commission found that a staggering 60% of all arrests in India at the time were entirely unnecessary or legally unjustified.
60%.
Yeah.
That's insane.
It's a devastating indictment of the executive branch.
More than half.
Yeah. It suggests that the majority of arrests were not being utilized as a necessary tool for criminal investigation, but rather as a mechanism of harassment, intimidation, or corruption.
The power of arrest had basically become the primary currency of police malfeasance.
Yeah.
We have to look at the structural fallout of that metric, because the commission also estimated that these unjustified arrests accounted for 43.2% of the expenditure of the entire jail system.
So we aren't just talking about individual liberty violations anymore.
No, we are talking about the economic and structural collapse of the justice system. The state is cannibalizing its own resources, spending nearly half its prison budget to house, feed, and manage citizens who legally should not be incarcerated.
And the collateral damage on a human level is incalculable.
Right.
The judgment notes the profound indignity and permanent reputational harm inflicted by a stint in police lockup.
You don't just brush that off.
You really don't. When the system weaponizes arrest to that degree, it erodes the foundational legitimacy of the state. So the Joginder Kumar case became the Supreme Court's mandate to surgically dismantle this practice.
To explain how they dismantled it, your presentation must transition to the specific legal framework and constitutional provisions the court deployed. This covers points 6 and 7.
The bedrock, of course, is Article 21 of the Constitution.
The guarantee of life and personal liberty.
Yes. The court essentially states that routine, unjustified arrests are structurally incompatible with Article 21.
It's a direct violation.
And they reinforce that with Article 22(1), which secures the right of an arrested person to be informed of the grounds of arrest and to consult a legal practitioner.
But wait, the Supreme Court didn't just look at Indian law, right? They went global.
Yes, if we connect this to the bigger picture, what is truly fascinating about this judgment is how far beyond domestic statutes the court traveled to find a functional remedy.
Right.
They didn't just rely on Section 57 of the CRPC, which, by the way, is now Section 58 of the BNSS 2023, regarding the reporting of warrantless arrests to the district magistrate.
They looked to international standards to engineer a practical mechanism of restraint.
This is where you demonstrate real depth in your analysis to the faculty.
So what did they look at?
The Supreme Court deeply analyzed the UK Police and Criminal Evidence Act of 1984, which was born out of the Royal Commission on Criminal Procedure, led by the Sir Cyril Phillips Committee. And what the UK had codified is highly relevant here.
How so?
The Royal Commission had recognized the exact same crisis of public confidence in police powers in the UK.
So they were dealing with the same problem.
Exactly. And their solution was to introduce the necessity principle.
The necessity principle.
Right. They argued that the power to deprive someone of their liberty should be severely restricted and only exercised when genuinely necessary based on specific practical criteria.
So the necessity principle acts as a filter.
Yes, a very strict filter.
Under this UK model, a police officer can't justify an arrest merely by establishing reasonable suspicion that a crime occurred.
They have to pass a secondary test.
Which is the arrest practically required?
Right. Will the suspect destroy evidence if left free? Will they intimidate witnesses? Are they likely to abscond and fail to appear in court?
And if the answer is no?
If the answer is no, the state has no business putting them in handcuffs, regardless of the underlying suspicion.
The UK framework also emphasized the use of summonses or appearance notices for lesser offenses, right?
Yes, requiring individuals to present themselves at a specific time rather than executing physical arrests out of nowhere.
And the Indian Supreme Court absorbed this logic entirely, recognizing that India desperately needed a similar criteria-based restraint on police discretion.
But beyond the UK framework, the court utilized a highly specific piece of domestic law that showcases just brilliant judicial synthesis.
This part is so clever. They pull in Section 19A of the Children Act.
Yes. So Section 19A mandates that when a juvenile is arrested, the police are legally obligated to inform a parent or guardian immediately.
The legislative intent there is clear, right? A child is vulnerable and requires an external advocate to navigate the terrifying machinery of state custody.
Exactly. But the Supreme Court extracts the underlying principle of that statute and applies it to adults.
The logic is impenetrable.
It really is.
Because think about it. An adult thrown into an unacknowledged detention like Joginder Kumar is functionally just as isolated and powerless against the state apparatus as a child.
The fundamental right isn't about age.
Right.
It's about the right not to be disappeared. An adult in custody absolutely requires an external lifeline to ensure constitutional safeguards are activated.
This comprehensive synthesis of Article 21, international necessity principles, and the protective logic of juvenile law culminated in the Supreme Court establishing formal, mandatory requirements.
And this brings us to point 9 of your presentation, the judgment and the specific mandates handed down.
Because the legislature had failed to codify the necessity principle, the Supreme Court basically used its immense constitutional authority to write what was essentially a binding operational manual for the police.
They laid down 5 distinct mandates to force transparency into the black box of police custody.
So what does this all mean? Let's analyze the mechanics of these mandates, because this is where the theory actually hits the pavement.
Okay, the first mandate establishes the right to inform.
Right to inform.
An arrested person is legally entitled to have one friend, relative, or other interested party informed of their arrest and the specific location of their detention.
But the second mandate is what actually gives the first one teeth, right?
Yes, the duty to inform.
The police must proactively tell the arrested person about this right as soon as they are brought to the station.
This is a crucial shift in the procedural burden,
Why?
because you cannot expect a terrified citizen, largely ignorant of case law, to spontaneously demand their right to communication.
Right. They don't know what to ask for.
Exactly. By placing the affirmative duty on the arresting officer, the court ensures the right cannot be quietly bypassed through omission.
Okay, so then the third mandate requires a diary entry.
The police must record in the official station diary who exactly was informed of the arrest.
Now, I want to view this critically for a second.
Sure.
If we are dealing with the reality of 1994 Indian police stations, where we know 60% of arrests are unjustified and corruption is systemic,
Yeah.
does a mandate to write something in a paper diary actually deter a malicious officer? Couldn't they simply falsify the entry or keep a secondary set of books?
It's a really valid critique, and it acknowledges the limitations of administrative safeguards against willful malfeasance.
So why does it matter?
However, the diary entry requirement serves a structural purpose. It creates a physical, time-stamped evidentiary trail.
A paper trail.
Exactly. Before this mandate, an officer could simply shrug and claim he was never here or he was just cooperating, just like the SSP did in this very case.
Right. The cooperating excuse.
But once a formal diary entry is mandated, failing to make it or falsifying it elevates the officer's actions.
From what to what?
From a mere procedural oversight to documented perjury and deliberate evidence tampering. It shifts the evidentiary burden significantly during a judicial inquiry.
It forces the police to manufacture a lie on official state records, which is a much higher risk proposition than simply utilizing an unrecorded, undisclosed destination.
Precisely. And this ties directly into the fourth mandate, judicial oversight.
Judicial oversight.
The magistrate before whom the arrestee is produced is legally required to actively satisfy themselves that these requirements have been complied with.
This mandate attempts to transform the magistrate from a passive administrator of remands into an active inquisitor of police procedure.
Right. The magistrate must question the police and the accused to ensure the diary entry exists and the rights were actually communicated.
Again, looking at the structural realities, though, magistrates handle crushing caseloads.
Massive.
The risk is that this oversight becomes a rapid-fire mechanical checklist rather than a substantive inquiry.
True, but the court's intent is clear here.
Mhm.
The judiciary must act as the primary firewall against executive overreach at the very first point of contact.
Which brings us to the fifth and arguably most crucial mandate, recorded reasons.
Yes. Police officers are mandated to record the specific, actual reasons for making the arrest in the case diary.
They cannot merely cite a section of the penal code. They must articulate the necessity,
They have to show their analytical work.
like a math test.
Exactly. If they arrest someone, the diary must reflect the specific justification. For instance, suspect has a documented history of witness tampering, or suspect possesses dual citizenship and poses an immediate flight risk.
This directly operationalizes the UK's necessity principle we talked about earlier. It strips away the cloak of the routine arrest.
And the Supreme Court directed the Directors General of Police across all states to issue strict instructions implementing these requirements immediately.
They didn't mess around.
No, explicitly stating they flowed directly from Articles 21 and 22. These were not suggestions. They were binding constitutional directives meant to hold until the legislature formally amended the procedural codes.
So when you reach the conclusion of your presentation, point 10, your goal is to synthesize the legacy of this ruling.
Right, bring it all home.
Joginder Kumar is the watershed moment where the Supreme Court declared that the power of arrest and the justification for arrest are legally distinct concepts.
It is the moment the judiciary recognized that absolute discretion in the hands of law enforcement inevitably decays into the insolence of office.
You summarize that by mandating third-party notification and recorded justifications, the court sought to eradicate the terrifying phenomenon of the disappeared suspect.
They forced a rigid framework of transparency onto an apparatus that thrives in opacity.
To leave an indelible mark on your faculty, you must close with the precise philosophical statement the Supreme Court authored in this judgment.
Oh, this quote is powerful.
It is a quote that transcends procedural law and speaks to the very soul of a democratic state.
The court wrote, "The quality of a nation's civilization can be largely measured by the methods it uses in the enforcement of criminal law."
That is a profound metric.
It really is.
It asserts that a nation's advancement isn't measured by its GDP or its technological prowess or its geopolitical influence.
No.
It is measured by what the state permits its agents to do to a citizen in an interrogation room at 3 a.m.
If a state relies on arbitrary detention, obfuscation, and the violation of fundamental liberties to maintain order,
It fails the baseline test of civilization, regardless of the sophistication of its written constitution.
it is the ultimate reminder to the legal community that procedural safeguards are not just bureaucratic hurdles.
They are the structural, load-bearing walls of a free society.
Delivering that analysis will absolutely command the room.
You have the factual narrative, you have the philosophical tension between Cardozo and Hand, the international integration of the necessity principle, and a critical understanding of the practical mandates. You are deeply prepared.
You're going to nail it.
But before we wrap up this deep dive, there is one final, incredibly prescient thought embedded in this 1994 judgment that demands your attention.
Something to mull over later.
Right. The Supreme Court makes a sobering admission. They acknowledge that their constitutional perspective cannot be absolutist, noting a societal gravitation towards prioritizing the conviction of lawbreakers.
And they write this highly specific phrase that really stood out.
They said, torture technology, crime escalation, and other social variables affect the application of principles in producing humane justice.
The court explicitly acknowledging torture technology and crime escalation as variables that continuously stress test these constitutional protections.
Consider the implications of that in our current reality.
Think about it.
The court wrote that in 1994. Now, project that warning into an era defined by mass digital surveillance, biometric tracking, predictive policing algorithms, and the borderless scale of modern crime.
The tools of statecraft and the methods of enforcing criminal law have evolved exponentially.
As the perceived threat to society escalates, and as the technological capacity of the state to monitor and detain becomes near absolute, we have to ask ourselves something.
A difficult question.
Will the procedural firewalls constructed in Joginder Kumar hold the structural load?
Or will Louis Mayer's pendulum swing violently back, prioritizing an insatiable demand for security over the fragile architecture of individual liberty?
It's a question the text forces us to confront, and one that every generation of legal minds must answer.
Yep.
Thank you for joining us on this deep dive. You have the insight, you have the analysis. Go deliver a phenomenal presentation.